Bus. Hey guys, I'm back for another part 2 of our trust video. I want to say excuse me for the other day. I was like getting over something, and at the end of the video, it was like, you ain't over it. Alright, so hopefully I can get through this part without having those issues. Today, we're going to go over a little bit more into trust, understanding what a trust is, the benefits, the disadvantages, the type of trust. We're going to go through it all with these series of videos. But today, I want to go into maybe the disadvantages and some of the protections that a trust may give you. Okay? So, protects your privacy. Like all trusts, living trusts maintain distant privacy more than wills, since these typically no public records is required. However, if the trust is funded through a pour-over provision in your will, this item's transferred from your probate estate may indeed appear in public record. So let's find out what is a pour-over provision. Pour-over provision is usually something that is put into the trust when you pass away. And sometimes most of the times, if it's in a will, like, it has to be going through probate to get into it. So it's always good. It seems like it's good to get all your affairs handled with the trust instead of having the pour over effect. And this is when you may indeed appear in public record in regards to the items, the estate that you're putting into this trust. Okay. And in some states, if you put certain kinds of property in the trust such as the real estate, securities, or a safe deposit box, you may have to register the trust, which creates a public record of its content. You may not be able to get around this request through use of nominee partnership. So it said you may be able to get around that with nominee partnership. And later on, we're going to go over nominee partnership. I did print out some information in regards to what's a nominee. That's someone who you can appoint as an overseer or entity. And we'll talk about that nominee. A nominee is someone who is given limited authority to act on the behalf of the entity, usually for a limited period of time and usually during the formation of the entity. The principal officers, general partners, etc., as defined by the IRS, is the true responsible party for the entity instead of the nominee. The responsible party is the individual entity that controls, manages, or directs the entity and the disposition of the entity's funds and assets, unless a nominee who is giving little or no authority over the entity's asset. The Internal Revenue Service has become aware of nominee individuals are being listed as principal officers, general partners, guarantors, owners, and trustors in employee identification number of application process. A nominee is not one of these people. Rather, nominees are temporarily authorized to act on behalf of entity during formation process. The use of nominees in the EIN application process prevents the IRS from gathering appropriate information on entity ownership, FYI, and has been found to facilitate tax non-compliance by entities and their owners. So I think this is where some of the trust issues was coming up with people trying to, put things into the trust and take it out or hide things in the trust. And these are one of the formal ways they were doing it, through a nominee. Okay, so you could go deep into detail about that. Okay, so easy to create and easy to change. For most simple estate, it is not that hard for a lawyer to create a living trust tailored for you estate objectives, and you don't have to go through the formalities required to execute or change the wills. Some state require that your living trust be registered with the state, but that's simple. That's a simple procedure. Most states require no witnesses or legal voodoo to execute the living trust, or an abandonment. Addendum to it. So addition to it, excuse me, not abandonment, addendum to it. Just have your lawyer write it or do it yourself. Though it is risky, see below, sign your name. So mostly you have to be on point with any changes or even creating the trust. You have to be on point. But one of the things they say is when you sign, don't sign as yourself, sign as the trustee. Okay? So greater control over assets is, in some states, a spouse cannot take an elective share in a trust asset. See discussion of taking against the will in chapter 7. So that's another part of the book that we may discuss and we may go down. Making living trust a way of disinheriting a spouse in these jurisdictions. So when I was going down, reading a little bit more, it was saying how people can get through the trust issue when they have a spouse and they want to split estate. They actually can have two different trusts, 50% of the estate in one trust and 50% in the other trust if you don't trust your spouse. And if you get married to somebody you don't trust, what the hell are you getting married for? That's all I'm saying. So anyway, good for the fairy. It says good for families and assets. Say you want your estate administered by someone who doesn't live in your state, usually a child who's grown up and moved away. A living trust might be better than a will because the trustee probably won't have to meet the residency requirement. So it's a residency requirement in some states for wills to be executed. And with trust, you may not have that issue. Resident requirements some state laws impose upon executors. If you have property in other states, many lawyers recommend setting up a living trust to hold the title to the property. This helps you avoid time-consuming, complicated probate processes. Disadvantages. And this is where I wanted to get in. Disadvantage of the trust, because everyone's like, trust is so good and you don't get taxes. And let's clear this up. Okay? Cost. While a lawyer isn't required for setting up a revocable trust, it's usually a good idea to hire one. Though there may be some eventually saying it reduce or eliminate probate costs, registration fees, and other initial costs of the trust is incurred up front, while the savings generally does not occur until death. Okay, with probate, you usually get all your fees and stuff after, before everybody get their stuff. Title problems. Not all items may be easily transferred into the trust. Jury can be a problem, and if transferred title to your car into the trust, you may have trouble getting insurance on it since you don't own it anymore. So, that's an easy fix. Some people, okay, this ain't the channel for that, but that's an easy fix. You can get insurance probably because you're creating an entity, and if that entity has an EIN number, and I know they don't have a driving record, but that is a business, and then you as the person is going to be the party responsible. You may not have a problem getting insurance. But this is why Moors, and I'm not going to say Americans, Moors, they actually don't have insurance because they put their car in trust and they don't need insurance, FYI. This is not the channel for that, but you go on my other channel, you could go research some of that stuff. Okay, so tax problems. Let's move on, because they was like, oh, you don't pay taxes, it's untouchable, and that's not the truth. The federal estate tax allows on estate to use a year other than the calendar year as the taxable year used in the deadline. So you use the year prior. Trust doesn't receive the same flexibility. If you have a large estate and timing is a consideration, it might save you money to pass your assets via will instead of trust. Because if you're not time efficient and on point, then you may have some issues. You don't have to have a separate tax ID number for a living trust, but trusts are required to make estimated tax payment, while estates are exempt from the requirement for the first 2 years. Okay, so if you put a estate in the trust, it does not mean that you're not going to pay taxes on it the first 2 years. You don't have to have, okay, so I read that for the last 2 years. They may, there may be state tax consideration too. Maryland, for example, charges income tax on trust, but not estate. Check your state law for such traps before setting up a living trust. So you have to go on your state code. Your state registry where they have judged the laws, and I'm going to tell you where I'm in Georgia. So I went to IRS.gov to find out, what is a nominee. You can go right on and go and see what they say it mean. You go to the Black Laws Dictionary, go to banking dictionaries, and you also go to their website and see what it means, because you may be having a misinterpretation. As well as when it goes to laws, I went on Georgia, I think it's I had it up, it's OCU. See if I can find it for you guys. I think I got it. I had so much stuff up here. But later on my next series of videos, we're going to go over some of the laws in Georgia that actually governs trust and how to set it up and when it's considered a trust and when it's not. So you have to go into your state law registries and learn about what is their trust laws, okay? Less protection. A trust administration is not an estate administration, and you don't have the protections of claiming, period, nor are you in court with any expedient way for the court to settle disputes over constructions of documents, issues of facts regarding status of beneficiaries. If there's issues, if those issues are to be determined by a court in a trust administration, a separate cause of action needed to be filed with a summons. Related costs and time delay is consideration is in continued situations as the state's administrations is best. So it says that the state administration is better, and we'll go down that route and get clarification of a state administration and why it's best. We're going to highlight that for now so we can make another video on it, because it's all about living and learning, guys. And I will share, I thought I shared the link earlier on the other video, but I will copy and paste the content that I'm reading to you guys so y'all can read it yourself. I ain't perfect, but I'm doing my best for you and me so we can grow together. So moving on, other tip, revocable trust, along with other non-probate transfers like insurance policies, are not automatically revocable or amended on divorce, unlike wills. So when you have wills, like with divorces and things, certain things are just revocable. Like they expect you not to have fucking insurance together. But then when you do stuff like that, you put it under the trust ain't married to nobody. So the trust like, hey, you ain't changing stuff like that. So if you don't amend the trust, your ex could end up being the beneficiary, okay? So it's chapter 9 that goes into that. We're going to be reading that up. It's going to splitting up and divorcing and remarrying, because all of that plays a part with people who have a trust. If you're in a certain specialized situation, you might ask your lawyer whether a trust is a good idea. It can, if not properly probably jeopardize medical qualifications and may any land received via the trust subjected to law pertaining to toxic waste cleanup. So we have to go into detail with that, because I'm actually purchasing like land. So I purchase tax liens, and with that, if I'm opening and if I'm actually purchasing and putting it under a trust, I need to know what the laws is for it. So obviously it's saying if I have a property under trust, I have another obligation to me as a trustee or as a trust to be subjected to laws pertaining to toxic waste cleanup. If you receive some land via will, you will not be liable. So if you get it through the will, you're not liable. But if you get it through a trust, then you're liable for toxic waste. So that's something new. something new, something to think about, guys, because if you're doing estate planning, depending on the state the property is located in, put your home in a revocable trust might jeopardize the homestead exemption. Okay, so you got to think about that. So you can put a home inside of a trust that's not paid for, because people had questions like, can I put it home? I'm still making payments on it. You can put it into the trust. You just have to sign it over into the trust. Depending on the state the property is located on, putting your home in a irrevocable trust might jeopardize the homestead exemption, might require a transfer fee, or might cause property to be reevaluated for property taxes purposes. Okay. Finally, through a living trust, you write while living in one state remain valid. If you move to another, it's a good idea to check the laws familiar with the statutes of your new state to see whether the trust should be revised to account for difference in the law, especially if you're moving from a community property state to a common law or vice versa. And that's what people need to understand. Sometimes we're living in unincorporated land and we don't know that. And people just live because we don't understand land. We don't understand land title. We understand incorporated, unincorporated. We just live in. Unincorporated land is land that's not subjected to some laws and statute treaties that incorporated land is. They also may not have the rights to have fighters come to their house, garbage disposal, sewage, things like that. They're responsible. So it's sections in Georgia when you drive through, it'd be like, wait, where the hell happened to the road? It's a dirt road and it's nothing. Like, it's just houses deep in the trenches, and you know that's an unincorporated land. Like the other day we were driving by, we saw half a deer body in the middle of the road. It was so freaking crazy. But unincorporated land, they may be living like they want to. Okay, so practical steps in setting up a living trust is going to be the next video. That's going to be video number 3. Practical steps on setting up a living trust. I got a website already that I can help you do the living trust easy. It's like a fill-in. I don't recommend it to do it that way, but I always recommend to look at different sources and kind of make your own and put it together and make sure that it's legal for your state. Because like coming into Georgia, they're really not as flexible about the way you hand in your court documents. So it has to be a certain way where you could go into court into another state, like where I'm from, Jersey, and put in an affidavit like bam, 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 get it notarized, get out of my face. But here they want plaintiff versus defendant, date here, just perfect legal form. So you have to pay attention to that, guys. So I thank you today for bearing with me. I'm glad I didn't have my coughing spell in our trust series. I do hope that you understand and you got a better understanding of trust just a little bit more. Also know that trust is not totally protected from taxes, so you should go in and learn your state laws. A state is not totally protected from taxes in trust. And as reading this, it says about 2 years you can have a state in there without taxes, depending on your state law. So do your research, guys. Thank you for being here with me. The next video I'll be sharing later on this week, it will be practical steps in setting up a living trust. Okay? Have a blessed one.